Right, this is the third part of my discussions into jurisprudence, and this is the third part of the history of jurisprudence and democracy. You'll recall that the last occasion in the second tape we finished when I mentioned procedural natural law. I pause so you can just take that in. And natural rights. Now, procedural natural law was attributed to a chap called Lon Fuller, Fuller, and natural rights were attributed to John Finnis, Finnis. Now, procedural natural law is also called procedural naturalism. But before we go to that, I pose the question: Was the Third Reich, was Nazism validated by law? Now, I think in the sense of legal positivism, it was, because legal positivism only needs the right lawmaker to make the law. In other words, the one who carries the law for the authority, the sovereign. And so I would suggest it is, but you'll find a bit later on that there are views to say that it's not, because it doesn't comply with the goodies, the good things in life. I'll come to that in a moment. So what are we talking about morality? Fuller suggests there are principles of legality, procedural principles that need to be followed before you can have a legal system which is firmly based. He says that morality is certainly a principle, but it's not necessarily including a religious base, and that procedural law requires some morality into it. And he uses the phrase, a minimum system of morality behind it. Well, you know, it's good to say that, because obviously he's talking about natural law, so there must be some element of it. But I don't know how you refer to minimal element of morality. I would have considered a large element of morality as well. And so when there's no morality and the law itself is evil, then it can be rejected. So evil law can be rejected because it's not law. Nazism, therefore, can be rejected as not being lawful. But of course, it's enforced by the state. And so it's not an easy answer when you're looking at what happened in Nazi Germany. And you can see why the world started to look at rules that would try and prevent further wars and also disagreements between states. Now, he gives the description or an example of a chap called Rex, R-E-X. Now, Rex is a monarch and he's not very competent at it, so he needs help. But he wants to be an hereditary monarch. And so Fuller is advising him, saying, these are things you should not do. These are not to do principles when you are making law. So Fuller says that Rex must not make laws according to 8 principles. Number 1, he should not fail to make established rules at all. In other words, anarchy. That he should not fail to make the law public so the public know about it. He says he should not fail to make the law prospective and not retrospective. Well, that means that it makes sense, really. You can't judge a person for what he did before the law came into force. Fourthly, he fails to make the law clear. Well, that's sometimes, we still fall for that now, actually. Fifthly, and this is with law, it really is taking law, making law clear. This follows on from that, really. It's a failure to make the law free of contradictions. So avoid contradictions. 6, failing to make the law capable of being complied with. In other words, we're setting the behaviour standard at a level where nobody could comply with it. And number 7 would be to make the law consistent. And finally, fail to make a connection between the law and the administration dealing with it. So if these conditions are not met, then it fails to be a legal system according to him, with the element of morality brought into it, a minimum element of morality. I do think that after World War II and human rights legislation since then, and the lawmakers have actually, or the rule makers, to be more precise, in international law, have been trying hard to make these principles effective. And also, of course, the purpose is to make it moral, to stop wars, to regulate states. So now we turn to the theory of natural rights, and that's by John Finnis, Finnis. Natural law, now this is quite interesting. This is the one I prefer, actually. This is where law and morality are in the same place. They're in the same room. And he says that it's important law conforms to morality. Bingo, I do as well. And we've got to consciously make that happen. And I'm not sure we do it very well, because ideology often overtakes it, nationalism overtakes it. So what's more important to the nationalist? Nationalism. To humanist? Morality. So natural rights relate to specific laws or rules. And what they're meant to do is create the moral good of society. I was trying to think of an example, and a very quick one I thought of was public order legislation. It's to give everybody the right to remain safe and not to be abused and interfered with. So the takeaway here is that law should be made following regulated rules, made by an effective authority, and it should be for the benefit of the whole community. The law should be supported by sanctions and a way of resolving disputes. So now we're getting nearer to what's actually happening in the world. So you need an effective authority for the community making the rules. There should be sanctions for it, and there should be ways of resolving disputes. So it's law based on practical reasoning and the basic good, which is something I can't argue with. Right, so that deals with the moral side of philosophy and the religious side of philosophy and the moral good side of it. But legal positivism is the next field that we're talking about. Now, legal positivism is probably the most important theories in our modern times. Natural law tended to wane off in the 20th century due to things like the Holocaust, the Russian and Chinese threats to our society. Legal positivism, you'll be sad to hear, is also hard to define. In a sense, it means law laid down by an authority, and its validity objectively verified by a recognized source. So we're looking at a monarch. So law being laid down and its validity objectively verified by a monarch. It rejects the natural law theory that the law relates to human morality and does not accept a connection also to moral philosophy. So it's what the law is. Legal positivism does say, however, that natural law could exist on the periphery, but law and morality do not coexist in the laws of the Third Reich, for example. Legal positivism says that the history and sociology are not central to decisions in creating law. So basically the lawmaker makes the law, gives it the validity basis, and things like morality, history, sociology are not central to that, necessarily central to making law. So how can I make this a bit more understandable? Legal positivism focuses on what the law is and not what the law ought to be. So looking at the history of legal positivism, there is a number of academics that have contributed to this. I cannot possibly cover all of them. I'm trying to pick out the main ones to at least give you the idea of what we're discussing. I mean, there's a chap called Raz, R-A-Z, who I don't think I specifically will be mentioning, but you know, it's somebody that you can look at if you decide to take the study further. So why was there a decline in natural law? Well, it turned after medieval times and the Christian Renaissance and so on in the West. We became more secular. It was secularization of society which caused the decline, and also the development of atrocities by states, let's be blunt about it, by states creating laws which were cruel against its own people, or indeed other people. So that's why natural law came in decline. My argument is we got to go back to that, and we got to drag it kicking into current law thinking. Now, I'm also going to discuss Blackstone. Now, there was a guy called William Blackstone, who was around about the 1700s, and he described common law principles. He said they were transcendent as principles of law. It's a kind of natural law because by virtue of where it came from. And so natural law is a kind of common law. It was law that had been created by custom and rules since humanity started living together. What this meant was that he said when judges and lawyers looked at the common law, they weren't creating law, but trying to discover the principles which pre-existed in it. They discovered existing law in essence. They revealed what the law was and is. And there is something called Blackstone's Commentaries, which the United States used heavily or relied on heavily in the creation of the Constitution, in the sense of protection of the people, their freedoms, and their property. So these principles of common law are important. On another one of my postings, there's something discussed as jury equity. It's where jury has a right to go against any law for whatever reason, cannot be questioned. I believe that came from common law, and it's clearly law, but it exists. But advocates can't use it because they could professionally misconduct, and judges can't mention it. But there it is, live and kicking, and it's becoming increasingly important in modern times, where the state is trying to control behaviour and thought by using the criminal law, particularly on issues of sociology and politics and morality. I strongly urge you to look at those lectures, whether you agree with it or not. I hope they're interesting. Very difficult to keep subjects like this gripping, if you like. That's why I broke them into sections. So anyway, the natural law declines in popularity, and challenges are because of the political developments that are going on in more recent history, such as the English Revolution, the French Revolution, and the American Civil Law. What became important was the ideas of the rights of men, fundamental freedoms of liberty, and particularly, again, people mentioning Hobbs, Locke and Russoeau, the social contract they supported, so the rights of men and freedom, and also John Austin, Jeremy Bentham, in the late 18th century, were all part of this group of thinkers that related to what we're discussing, and the rights of man and freedoms. John Austin said that the law can be separate from morality, and authority of law came from a sovereign power. So let me rephrase that a bit better. Law is separate from morality because the authority of the law relates to a sovereign power, not the morality. Of course, legal positivism can consider concepts of morality and anything, but it's not linked to it. It doesn't have to be linked to it. I'm beginning to think that we have to link morality to laws. The sovereignty, and why? Sorry, let me just pause there. Why do I say that? Because it must make better laws, in my judgment. So the sovereignty could be a king or a parliament. There are no transcendental principles. Legal reasoning is based simply on the logic of the sovereign power, and no evidence is required, no external facts the laws relying on. So basically, legal positivism, Parliament can do it, the king can do it, and they can do it on their own logic. That brings us back to the Greek idea of benevolent leaders, or leaders that were trained from birth to be good leaders. Relying on a sovereign power or state on their own logic without anything else could be dangerous. So what does this mean in practical terms? Well, it means that international law is not true law, according to Austin. Why? Because it's not dependent on a sovereign authority. Its basis comes by agreement and consensus of individual states. International law, the Austin following would say, exists, but it's not the same as sovereign law. I would agree with that, I think. But I do still think principles of jurisprudence, when looking at positive law and natural law, can easily and is easily applied to international law when examining it. In fact, my personal view is that natural law is a fundamental brick upon which international law was built. So what's Austin's definition of law? It is law established by a political community upon the authority of a sovereign power. The law, put it another way, derives expressly or tacitly to the authority of the sovereign. So the law can be made on command by a monarch, a parliament, or leader. So there's the separation concept. It's legal positivism when it's separated from natural law and depends only on the authority of the sovereign. There are no required concepts such as fairness, equity, morality. They exist but do not influence the law. The law can align with those concepts, but only if the king or the monarch or the sovereign wants it to do so. We now look at enforcement of law, which is institutional enforcement. this means military or police forces enforcing it. So you've got legal, what the law is, and the enforcement of it. It doesn't seem to need education as to the enforcement of it. And I think that, and you will see later on, that I think that really coercion is not an element of enforcement that one needs to rely on, except as a last result in the seeking the common good. And I'm going to stop there, because the next talk is going to be about modern legal positivism. And that brings us really to more contemporary times. So I'll stop now. So this is number 3. The next one will be part 4.